Chief Justice, Your Honors, good afternoon. May it please the Honorable Court. Our constitutional fathers said, when we write a constitution, we write not only the fundamental law, but we also set the tone of a whole civilization. A commitment to the protection of life, even in its incipient stage, is a declaration of a commitment to a higher tone of civilization. It was then, after impassioned debates and meticulous deliberations, that the primordial right to life of the unborn from conception was enshrined in Section 12, Article 2 of our fundamental law, a unique and marked distinction of the 1987 Philippine Constitution, which sets it apart from other constitutions in the world. By providing that the life of the unborn shall be protected from conception, the framers of our Constitution intended to define the beginning of human life to be at the moment of conception, and did not intend to leave it for Congress to determine. It was made clear that conception refers to fertilization, and that fertilization or conception is the meeting of the egg and the sperm, resulting in the formation of a zygote or a fertilized ovum. The Constitutional Commission recognized that the fertilized ovum is alive. It has life. It divides at a geometric rate in the continuous process of cell division and development as it travels from the fallopian tube to the uterus. This, undoubtedly, Your Honors, is a vital sign and a functional evidence of life. Also, the fertilized ovum is human. It has 23 chromosomes from the ovum combined with 23 chromosomes from the sperm to form a total of 46 chromosomes. A chromosome count of 46 is present only, and I repeat, only in human cells. It is a unique genetic composition that is neither the father's nor the mother's, but of a unique new human being. Therefore, Your Honors, there is human life at conception. The constitutional right to life of the unborn from the moment of conception is the most fundamental among all human rights, because all other rights emanate from and are posterior to it. The right to life gives birth to all other rights. Therefore, it was logical for the Constitutional Commission to recognize that the unborn has personality, though limited and presumptive, precisely to demand and claim this right to life from conception. Section 12, Article 2 is intended, 1, to eliminate every possibility that Congress will ever pass a law that legalizes abortion or makes abortion possible, and for the Supreme Court to ever pass a pro-abortion decision and to adopt the American doctrine allowing abortion as enunciated in Roe versus Wade. Second, to guarantee that the life of the unborn from conception is protected at all times, not only from death, but from every risk or threat of harm or injury of whatever form or degree, whether remote or direct, permanent or momentary. And for this purpose, every iota of doubt should be resolved in favor of the protection of that life from conception. Third, to ensure that the life of the mother and the life of the unborn from conception shall be equally protected. And fourth, to ban as unconstitutional any and all contraceptives that damage, injure, or prevent the fertilized ovum from reaching the uterus or deter the implantation of the fertilized ovum in the uterus. And these contraceptives are referred to as abortifacients. So how does the RH law square with the constitutional purpose and intent of Section 12, Article 2? Section 9 of the RH law requires a certification from the Food and Drug Administration that hormonal contraceptives, intrauterine devices, injectables, and other family planning products and supplies are made available on the condition that they are not to be used as abortifacients. Section 9 further provides that emergency contraceptive pills, postcoital pills that will be used as abortifacients shall not be purchased or acquired. Your Honors, by providing that the contraceptives are not to be used as abortifacients or that they will be used as abortifacients, hormonal contraceptives, intrauterine devices, and other family planning supplies and products have abortive capacity and can be used as abortifacients. Indeed, Your Honors, hormonal contraceptives and IUDs are, in fact, abortifacients. This approach under the RH law unquestionably puts the fertilized ovum or the human embryo at great risk because it substitutes the intention of the user for an accurate understanding of how the contraceptive works. Intending or hoping that the contraceptive once taken will not cause abortion is not a rational or defensible approach, Your Honors, because evidence abounds that once contraception is taken, it can and often will cause abortion. Similarly, a carcinogen causes cancer, regardless of its primary effect or the intention of the user. So how do contraceptives work as abortifacients? The Textbook of Obstetrics, 3rd edition, copyright 2008, and Williams Obstetrics, 23rd edition, copyright 2010. These are medical textbooks used by most, if not all, the medical schools in the Philippines, as well as Guttmacher Institute, which is the research arm of Planned Parenthood, which is the foremost provider of abortion services in the United States, Your Honors. They mention the following mechanisms of action of hormonal contraceptives that contribute to their high effectiveness. 1, inhibition of ovulation. 2nd is the thickening of the cervical mucus that retards or impairs sperm transport or penetration. And number 3, the formulations cause alterations in the endometrial lining, making the uterus physiologically hostile to receiving and sustaining a human embryo. The first 2 mechanisms, Your Honors, are truly contraceptive, which are inhibition of ovulation and thickening of cervical mucus, because they prevent fertilization and the formation of an ovum. But we do not stop there, Your Honor, because there's a 3rd mechanism of action which is built in and a backup mechanism and which is abortive in nature. So why is it abortive in nature? Because the fertilized ovum is unable to implant in the uterus because of the action of the contraceptive that has been taken. And if there is no implantation, the fertilized ovum is destroyed and expelled from the uterus. In short, Your Honors, the fertilized ovum is killed or aborted. The abortive mechanism happens when there is breakthrough ovulation or escape ovulation. As the name suggests, Your Honors, the woman who has been taking a pill still ovulates because the formulations of the pill are such that they do not 100% of the time completely inhibit ovulation. A simple practical proof of this, Your Honors, is that there were still women who got pregnant while on the pill. And cases of this have been extensively documented. So when breakthrough ovulation or escape ovulation occurs, this may pave the way for fertilization and the formation of a fertilized ovum. The fertilized ovum then goes to the uterus, which has become hostile to implantation because the contraceptive destroys the symphony of hormones which act in concert in order to prepare the uterus for implantation. As I have said, Your Honors, because the fertilized ovum is unable to implant in the uterus, the fertilized ovum is destroyed, expelled, and killed. Your Honors, from the legal as well as moral and ethical points of view, it does not really matter how often breakthrough ovulation occurs, or whether in each instance, whether embryo death does actually occur. What matters is that the fertilized ovum is exposed to a considerable amount of risk because of the abortive action of the contraceptive, and consequently, there is a significant risk for embryo death to occur. If Your Honors please, even if there is only one life or one death that occurs, and only one human life is lost, it does not make the situation any less indefensible or any less tragic. The proviso that the FDA must certify that hormonal contraceptives and family planning supplies and products are not to be used as abortifacients is illogical and deceptive, if not ludicrous. Your Honors, once the abortifacient drugs are distributed and there is a mandate to distribute them widely, the government will no longer have any control on how these drugs will actually be used. Section 9 also mandates the inclusion of hormonal contraceptives and IUDs in the regular purchase of essential medicines and supplies of all national hospitals. Including abortifacients among the family planning methods is abhorrent enough. Including them in the essential drugs list is totally despicable, Your Honors, for being an outright affront to the fundamental right to life. Essential medicines are those that satisfy the priority health care needs of the population. They are selected with due regard to disease prevalence, efficacy and safety, and benefit over risk ratio. Your Honors, pregnancy is not a disease, and the only medicines ordinarily needed by pregnant women are iron and folic acid supplementation, such as ferrous sulfate and multivitamins. And pregnancy or pregnancy-related disease is not in the list of the 10 leading causes of morbidity that cause a lot of deaths all over the country. But they include pneumonia and tuberculosis. And hormonal contraceptives and IUDs are not safe. As found by the International Agency for Research in Cancer, they are classified as carcinogenic to humans belonging to the group 1 carcinogens, which include asbestos and formaldehyde. They increase the risk of breast, cervical, and liver cancer, stroke, heart attack, thrombosis, and diabetes. Hence, the mandated procurement, distribution, and use are violative of the right to health. While hormonal contraceptives and IUDs are mentioned only in Section 9, written all over the RH law is the mandate for widespread dissemination and universal access to a full range of artificial family planning methods and devices, which necessarily include IUDs and hormonal contraceptives. Hence, Your Honors, it is our humble position that the infirmity resulting from allowing abortifacient family planning methods is not only limited to Section 9, but extends to the entire RH law. We are not impressed with the repeated use of the term non-abortifacient, Your Honors. The term is but a ruse to discourage valid objections against the RH law and makes the violation of the Constitution all the more repugnant. The terms abortifacient or abortifacient and non-abortifacient are poles apart. One is the complete antithesis of the other. They cannot be reconciled. So when a drug is an abortifacient, it necessarily is not a non-abortifacient, and vice versa. One cannot even separate the three mechanisms of action because the third mechanism of action is built in and is designed precisely to set in when the contraceptive mechanisms fail. This must be so in order to guarantee the total effectiveness or the high effectiveness of contraceptives. Representative Lagman, the author and main proponent of the RH law, and the other respondents and interveners have conveniently redefined and re-engineered the medical terms, Your Honors. They've defined conception as synonymous with implantation and claim that there is no human life at fertilization. They also claim that life begins only at implantation. If Your Honors please, this is totally irreconcilable to the avowed constitutional intent and purpose of Section 12, Article 2. Just as our constitutional fathers consciously and deliberately took the safest and most prudent approach to ensure that human life is protected from the very moment it exists, and that no human life is killed intentionally or unintentionally. We implore this honorable tribunal to do no less and to take the most reverential and safest approach likewise, by ensuring that the life of the unborn is protected from the moment of conception and resolving every iota of doubt or uncertainty in favor of the protection and preservation of human life. We do not need to wait for evil and more evil, for death and more deaths to happen, Your Honors, before we act. Hence our petitions. The constitutional right to life of the unborn is imperiled by the tyrannical mandate of the RH law, which is going to be implemented by the entire bureaucracy, starting from the cabinet level down to the barangay health workers in the remotest barangays, backed up by the vast resources of government. Into your hands, Your Honors, we entrust the future of our unborn, who are the most underprivileged, the most vulnerable, and the most defenseless members of our society. They cannot even utter a word or cry. or scream or beg. So with your permission and on their behalf, I now plead, Your Honors, let the voice of the unborn be heard in the august halls of this Supreme Tribunal. Let their voice be yours. Thank you, Chief Justice. Thank you, Your Honors.